Hi guys. I did a video last night with Wayfarer's letter to Judge Lyman requesting an extension of the pre-trial motion deadlines. Um, he has just come in. I'm just scrolling down now and confirmed that the extension request is granted. So those new dates are now going to come into effect. He's also confirmed that there's going to be a video conference via Microsoft Teams, which means that the public, will get a dial-in number. So I will be listening into that and then doing a video afterwards to just go over what was said. But that's going to happen next Thursday, that hearing on April the 2nd at 5 p.m. Eastern. Now, Lively did actually oppose this, but it was too late. Lyman had already issued his ruling. I'd be surprised if this letter makes any difference to that at all. But actually, this letter really pissed me off. So, yeah, be prepared to be annoyed. And I'll probably have a little bit of a rant as I'm going through it. Okay. So this is Lively's opposition to Wayfarer's request for the extension. She, like I say, she literally, this come on the docket just 10, 15 minutes after the judge's order. Okay. Dear Judge Lyman, Plaintiff Blake Lively respectfully submits this letter in opposition to defendant's request for a further 1-week extension of pre-trial deadlines. As an initial matter, this is defendant's third request in the past month for a continuance of pre-trial deadlines, which appears to be an incremental tactic to delay the trial in this case. Defendants have repeatedly taken the position that trial preparations are premature based on their bold assumption that they will receive a case change in order on the pending motions for judgment on the pleadings and summary judgment. I have to laugh at the brass neck of this woman to moan that requests for extensions, rather brief extensions, are a delay tactic when this woman didn't turn up for her deposition until the third or fourth scheduling of it and completely wasted everyone's time. We had, the lawyers from California who flew in. You had Jed Wallace's lawyers from Texas flew into New York just for her to then, wriggle out of her deposition. But this woman has got an issue with anyone else who, does anything that she claims will delay this trial, and it won't, by the way. But we'll get to that. They recently asked the court to implement floating pretrial deadlines tied to the court's ruling on such motions, which the court denied. Having lost that attempt, defendants have engaged in other delay tactics and self-help, including simply failing to comply with the parties' initially agreed upon pretrial exchange deadlines. For example, defendants A served their revisions to the proposed jury instructions a week after the previously agreed upon deadline, and B outright refused to respond to Miss Lively's proposed verdict forms. Despite the parties' agreed upon exchange schedule and defendants' explicit agreement to engage with respect to the verdict form. Second, defendants have misrepresented the state of pre-trial exchanges, suggesting that Miss Lively has engaged in bad faith and or purposely obfuscated anticipated trial exhibits, trial witnesses, or deposition testimony for presentation. This is false. As defendants acknowledge, Miss Lively is the plaintiff in this case and bears the burden of proof on 13 causes of action. I will say one thing, that comment, and that comment alone, that one line, is actually fair. She's right. She is the plaintiff, and she is the one who has the burden of proof. So if there's evidence, testimony, witnesses that she is going to rely on, then yes, she needs to put them all forward. So that is a fair comment. Okay, I hate when I have to agree with her, but I got to say it as I see it. And then on that one sentence out of this entire letter. That one sentence, I'm sitting there thinking, yeah, okay, you make a good point there. The parties' initial disclosures include more than 230 witnesses. Now, bearing in mind she's got 40 witnesses, the rest are potentially wayfarers. 89,000 documents have been produced and 37 witnesses have been deposed, many of whom reside outside the jurisdiction of this court. As such, the volume of exhibits, witnesses, and designations should come as no surprise to defendants and is proportional to the needs of this case. Moreover, defendants are represented by 16 attorneys and 4 law firms, as she's put those numbers in bold and italics just to accentuate them and highlight them. 16 attorneys and from 4 law firms that have entered appearances to date, and recently included 3 additional Shapiro Arato Bach attorneys in their latest transmittal of pre-trial materials. Right, I'm just going to the bit she conveniently leaves out here is right, and this is just so irritating because she's making it sound like what Wayfarer have is excessive. Those 16 attorneys, right, from 4 different law firms, which are noticed, i.e., they're noticed to appear on the docket. Firstly, that'll be the tip of the iceberg of what is really going on, because there'll be a lot more going on behind the scenes, as there will be for her. But also, that's for 8 defendants, because you've got, obviously, I think it's 8 anyway. You've got Justin Belloni, Jamie Heath, Steve Saueretz. You've got Jen Abel, you've got Melissa Nathan, you've got Vision PR, and it ends with Us Movie. And then Wayfarer. So that's 9 defendants. So that's less than, on average, 2 per defendant. Blake Lively kind of conveniently omits the fact that she is represented by 14 attorneys via 3 law firms. And that's just for her. And when she says, oh, there's 4 law firms, right? Mitra Ahurian is just she's a standalone. She is, has her own law firm. And she is helping out with the representation here. She was also at the premiere in the basement with Justin Baldoni and Jamie Heath and, everyone else. So has first-hand knowledge as well from that sense. But I'm sure she is helping out her friend. But to suggest this is a whole law firm when it is just one person from her own law firm, and then 3 law firms, 3 additional law firms who, apart from Shapiro, Arato, and Bach, they've been representing her from the start, which is quite is normal, because obviously Friedman's firm, it deals with the California law, and you've got Fritz's firm that deals with New York law. Shapiro and Bach, they bring in some of the more refined, more specialist and kind of appeal level experience and knowledge. And since they've been, doing filings, the difference is noticeable. Whilst Friedman and Fritz are amazing at their job, as are all the attorneys who work for them, there is a noticeable upgrade, shall we say, when Alexander Shapiro or Jonathan Bach write a motion or a letter. I think it really smacks of misrepresentation when Blake Lively sitting here moaning that 9 defendants have got 16 attorneys from 4 law firms, when she has got 14 attorneys from 3 law firms just for herself. It's a piss take. And likewise, her 3 law firms, one is New York, one is California, and one is Texas. And the reason I bring in the Texas law firm is because they're actually noticed here. Now, we know that Wayfarer is not part of the Jed Wallace Texas docket. But when Jed Wallace was involved, Laura Prather, who used to be Jed Wallace's attorney for his case against Bam Margera, Lively went and hired her. But she is actually noticed on this New York docket. She's attended depositions, not just the ones that involve Jed Wallace. She's attended depositions because there is overlap in some of the, the in the case basically here to, it leads to the case that's going on with Jed Wallace in Texas. So she has to be. So that's where she gets her 3 law firms for. On top of that, you've got other things like, you've got her initial lawyer as well, Lindsay Strasberg, has been attending stuff. And she's not included, by the way, in the 14 out from 3 law firms, but she has also attended depositions here. You've got Banzan, which is her company. Technically, it's her. Also has a set of lawyers too. So, and then there's her companies and businesses who, technically that's her again. And they have attorneys. So Blake Lively can shut up. I told you I was going to rant. I said I was going to rant. It doesn't get any better, by the way. Okay. So then she goes on to moan. These 19 attorneys are surely supported by many other attorneys who have not yet noticed appearances and who are capable of reviewing and objecting to evidence in a timely manner. Ms. Lively's counsel has worked diligently to cull the universe of documents, witnesses, and deposition testimony to those that may be offered at trial, and to review and promptly proffer their own objections to the hundreds of exhibits and pages of deposition designations provided by defendants on the parties' negotiated schedule. There is no reason that defendants cannot do the same. Moreover, Miss Lively's counsel already agreed during the conferral yesterday afternoon and again in an email yesterday evening, both of which occurred before defendants filed the letter motion, to evaluate the ways to narrow the exhibit list and, of course, to consider objections to initial deposition designations and to narrow the same. The offered relief should be more than satisfactory without the need for this court's intervention or a wholesale continuance of pretrial dates. Third, the noted technical glitch in Miss Lively's proposed exhibit list does not warrant a further week extension of pretrial deadlines. That issue, which defendants identified for the first time yesterday afternoon, just before their filing, is due to a purely technical error involving only the ending bait number on certain exhibits, which Miss Lively's counsel immediately agreed to investigate. To be fair, Wayfarer saying, well, yeah, that she had Lively agreed to investigate, but they didn't actually agree to, reduce anything for them to help them out. So, and that is why they weren't happy about that. Miss Lively had identified the source of the problem and agreed to both A, provide an amended exhibit list by today, and B, extend the deadline for the parties to exchange objections and further exhibit list extensions from March 27th to March 30th, which still preserves the April 3rd filing deadline. Defendants, of course, could have flagged this issue much sooner, but did not. The parties exchanged initial exhibit lists on Friday, March 20th, and mutually agreed in advance to provide objections and exhibit list revisions, if any, by March 27th. With that deadline in mind, Miss Lively's counsel promptly reviewed defendants' exhibit list and by Sunday had identified to defendants' counsel several deficiencies. Defendants, however, waited 5 days after the parties' initial exchange and just 2 days prior to the agreed-upon deadline to exchange objections to raise any concern as to how documents were identified on Miss Lively's exhibit list. Even then, defendants provided only general information, refusing to identify any specific impacted document. Defendants' own delay should not be rewarded. Miss Lively is, and this is the line now for the newspapers to run with. Miss Lively is, and always has been, prepared to take her case to trial and objects to any further attempts by defendants to delay her ability to do so. Right. This 1 week extension is not going to delay the trial. So, spoiler alert, Lively is talking out of her arsehole here. And that is purely for PR. Lively, she wants to go to trial, but Wayfarer keep trying to block her. What have they got to hide? That is where that is meant to lead to, that kind of speculation. But it's absolute nonsense. And this 1 week extension isn't going to, it's not going to delay anything regarding the trial. And we have a conference anyway next Thursday. So I'm looking forward to hearing what they have to say about it. But either way, this letter is now redundant because, as I said at the start, Judge Lyman has already ruled on it and agreed. He's granted the extensions. So those are now the new deadlines. Okay, guys, please, could you like and subscribe and hype the video if possible? Always helps me out. And I will keep you updated on any further, well, docket entries, I guess. Take care.